Yes.
So I just want to make one point of detail on pipelines and a couple of very short general points, and then I will sit down.
Yes.
The one point on pipelines is the suggestion by the defendants that the data that we ask for is likely to be, quotes, not a useful or reliable source of information to identify unknown or undetected leaks from the defendant's pipelines. I'd just like to take you to how this is put in the defendant's defence. It's in Core Bundle 2. This is the Bille Community Defence, which I don't think we've... Core Bundle 2, tab 34. So this is the defence we looked at a lot on the other appeal. And if we can look at two paragraphs in the defence, first of all, page 734, and paragraph 96A. And you will see there at 96A, we see that the second defendant manages oil spill detection through a variety of activities. And then if you look at the first one, is the Production Monitoring Centre, that's a little one. And that actually measures, that monitors line pressure and pipeline integrity. So the defendants obviously think it is relevant. And then if we go forward to 760, page 760, paragraph 118C, little 4, there's a reference there to that Production Monitoring Centre monitoring their pipelines, including line pressure on a 24-hour basis. So we say the court should reject the suggestion that this isn't useful or reliable source of information. Just one other point in terms of this specific disclosure. It was only requested on the basis, and this was always made clear, as a fast-track way to try and get some documents. So it was never said to be a substitute for full disclosure or standard disclosure, which I have shown you was also pressed for by the claimants throughout. That request was always put narrowly because the test for specific disclosure is difficult. Those were the documents that we really wanted to begin the process. It's not the beginning and the end of the process. And as I've said, we have received very little in response to even that narrow request. Finally, just a word on the order. We obviously will liaise with the defendant over the longer form order. In light of what your lordships have said, we'll also work today on trying to produce something short, which would be the essence of what we would ask you to order if the court felt it would rather do that than give detailed case management directions. So I hope that's of assistance. We will also work on that. And I'm also conscious that we will try and provide as soon as we can today a response to the document Mr. Willen handed up yesterday about what was in the public domain. So that's being worked on, a response which hopefully will narrow that down. Unless there's anything else I can assist you with, I'd propose to keep to my word 5 minutes and sit down.
Thank you.
Thank you.
Girls.
My Lords, I'm going to focus on our case as set out in sections 1 to 5 of our skeleton. And my Lords, I have that. That's the outline, the overview, the need for a proper pleading, the concept of global claim, and how the global claim concept can apply in principle in this case. Mr. Willen is going to address your lordships much more on the detail of the case management and the issues which arise from that. What I have in mind from that is the criticisms that are made of the judges what they've said about that. That's section 6 of our skeleton. So that's the broad division, though the lines may not be absolutely precise from time to time. I want to start by making 4 overarching points about why we're here before I get to the substance of our submissions. The first point is that the issue before the court is about the pleading of the claimants. It arises as a direct result, we say, of their failure to fully and clearly particularize their case on causation, despite the fact they were ordered to do so by Mrs. Justice O'Farrell in April 2022. I'm going to have to come back to her judgment in due course, but I'm afraid I must say my learned friend didn't do it justice when she took your lordships to it yesterday. In summary, Mrs. Justice O'Farrell ordered the claimants to plead causation properly by identifying which spills each individual relied on, where each individual allegedly suffered damage, and when each individual alleged that they first suffered damage. That was the essential information to be provided in the schedules of information. And Mrs. Justice O'Farrell explained and warned the claimants that without that there would be serious problems for the case. She made absolutely clear that the consequences the claimants would face if they failed to comply with her order to plead causation properly is that they'd be left only with what is termed a global claim. I'll come back, obviously, to how that comes about and what it means, but they were rather put to a binary election. Plead properly, or you are asserting a global claim. Doesn't mean your claim goes. It's possible to plead a global claim, but if you plead on that basis, that leads you into certain difficulties. And that we set out shortly at paragraph 21 of our skeleton. My lords, I've read that already and I don't need to read it again. But it's essentially that the claimants were put, to, as it were, to an election.
Can you show us her order? I'm sure you've seen it before, but I've forgotten what it said.
Yes, of course. I just need to be reminded of the reference to it. And that's, I'll be handed it in telling your chips. But it said the GLOs. The judgment is in the bundle. Is it helpful to?
I was wondering whether she made an order, and if so, what it was.
Well, she made an order about the particulars, certainly. She didn't include the. Let me not do it from recollection. Her order is at supplemental bundle 2, tab 22, page 443. And the bit, in a sense, I'm particularly referring to is paragraph F of the order, which is at page 449, which is the obligation, the order to serve particulars in relation to Bille of schedules of information containing the information that's set out there, which he just. And H on page 450 is where she includes the particular oil spill or spills in relation to which each individual claimant seeks compensation and damage and/or damages, or, if they're unable to provide such details, confirmation of the nature of the case they will rely on at trial.
Yes.
That's the binary choice. And I'll come to how that arises. But I want to just take my lords through that. All a global claim is in this context is really an escape route from an inadequately pleaded case in circumstances where a claimant has failed to plead has failed to do all the necessary work to plead causation properly.
When you say necessary work, is it your submission that the claimants and all of them have sufficient information to let all of them identify which spill they're relying upon?
They've got a lot more than they...
No, that's not an answer to my
No,
question.
well, I know, my lord, but we say, and I'll take my lord to this, if my lord will be patient, I'll take my lord to this, they have got information which would enable them to identify the spills that are relied on.
The order you've shown us doesn't put them to any election, does it? It just says if they're unable, then confirmation of the nature of the case they'll rely on.
Yes.
They've done that. You say it's not legally sound, but they have complied with the order.
Well, would you not permit me just to go through the steps, because
Yes, okay,
it shows how it all
Of course.
comes about. But the key point I really want to underline is what the court was faced with was a difficulty arising out of the claimant's failure to plead their case on causation properly. That's the concern.
But that begs a great many questions.
Well, it may do, and I will seek to answer at least some of them
Yeah.
as we go through this. But a point I do want to underline, it's true of the judgment of Mrs. Justice O'Farrell and also of the judgments of Mrs. Justice May. They were actually keen to avoid the difficulties created by a global claim. They didn't want that. They actually wanted pleadings and particulars rather than to go down the global claim route. But they were rather trying to encourage the claimants to produce further particulars under the threat, as it were, that otherwise they'd be faced with a global claim. The second thing I want to underline is that Mrs. Justice May found that the claimants were advancing a global claim, but left open the possibility that they would amend their particulars to replead their case on causation properly. That's paragraph 44 of her judgment of November 2023. I'll come back to that, but it's in the bundle, and core bundle 1, tab 4, page 47, my lords. I've looked at it.
Is this the second of your four overarching points?
Yes.
Yeah.
Yes. Yes.
Thanks.
And that shows, because that's an example of the judges below being keen to avoid the difficulties raised by global claims and wanted to give the claimants every opportunity to plead their case on causation properly.
Can you just give us the reference for that?
Yes, core bundle 1, tab 4, page 47. It's the judgment of November 2023. Just take it up. And that's the paragraph, page 47, where her ladyship says, despite Mr. Herman's rejection of the claimant's case as global claims, therefore, I consider that is nonetheless what they are on the present state of the pleadings, with the exception of the 5 Bille claimants, of whom I've referred to above. They were 5 who actually did identify the specific spills on which they were relying exhaustively. But she said, if in due course further claimants are able to tie their case sufficiently to enable identification of a specific incident or incidents causing, or possibly only materially contributing, that's where the material contribution comes in, to their loss, then there will need to be an application to amend, which will be considered on the merits of that time. And she noted that there was a possibility in relation to 412 of the Bille claimants who've given a bit more information about the incidents which might enable them to tie themselves to particular claims, particular spills. Even now that door has not been closed, the claimants are entitled to replead their case. It may be with leave, because leave is necessary, but they're entitled to replead their case to rectify the issue. And they sought and were granted specific disclosure to do this. And I want to come back to this. Although Mr. Willan will deal with the details of disclosure, one of the reasons, or the reason given for wanting specific disclosure, was so that the claimants could actually plead more specifically on these issues. And that disclosure, I'll come to this, was provided. Dispute about precisely what, but I'll come to that. Mrs. Justice may also, this is on page 47, referred specifically to the possibility that the global claim might not fail even if the defendants could show that they were not liable for a significant part of the overall loss. And that's paragraph 45 of this judgment. This is important. I'm not sure how much attention has been paid to it so far, and I invite my lords to look at it. And that's picking up on the comment by Mr. Justice Waxman, quoting from the judgment of Mr. Justice Aikenhead, in which Mr. Justice Aikenhead observed, and my lords will see it there, the fact that one or a series of events or factors caused or contributed or cannot be proved not to have caused or contributed to the total of global loss does not necessarily mean that the claimant can recover nothing. That's, may I call it the Aikenhead exception, but it's quite broad because, my lords have seen this in the cases already, it may well be possible for a claimant to demonstrate on the evidence that actually, even though there is some other event or some other cause involved, they can demonstrate that what they have suffered is solely due to the fault of the defendant, and then they can succeed, or that can be ring-fenced, is what Mr. Justice Aikenhead effectively was saying. And that's also important because one of the criticisms made of Mr. The judgments below, Mr. Justice May, was she didn't allow, she treated the defence of there's another cause as automatically defeating the claims, when in fact it doesn't. And it doesn't for two particular reasons. I'll come back to this. One is because there's the ability to replead the claims, to amend, to add a more specific case. And secondly, because of the Aikenhead exception, if you can demonstrate when the evidence has been produced that it's clear what the cause is, then you're not caught by this problem. The third overriding point I want to make is that we don't accept.
No, but hold on.
Yeah.
The criticism of the translation of the global claims doctrine isn't relating to a case where the claimant proves that the extraneous cause is not a cause. The criticism is, as I have understood it, relates to the case where the claimant there may be 5 concurrent causes, of which one is not attributable.
Yes.
Okay.
Yes.
In England, one would immediately start thinking about Hodson and Wiltshire and cases like that. But it's not. I didn't understand the submission to be talking about a case where there are 5 strands of the argument, and the one for which the defendant is not liable is held not to be causative.
No. If that's what I applied, it's not what I meant. I meant what my lord has put to me. If you have 5 causes, and it turns out that they were all causative, but they were not all the fault of the defendant,
then, on your understanding, the claimant loses.
Yes, and the reason for that, can I just put it this way? Yes, it's a label that's attached. It's logically right. As I think my lords have said, if you don't know what caused your loss, and you plead it was either A or B or C, that's fine, you can do that. But if when you get to trial, you don't prove it was A or B or C, all of those being the fault of the defendant, but it was D, which was not the fault of the defendant, then your case fails. And that's the logic of the global claim.
Well, you were going to tell us 4 overarching points, and then you were going to tackle the global claim issue. So tell us what the 4 overarching points are, and then we'll have some questions to ask about.
I jumped in with that, responding to my Lord's.
Yes, it's all my fault.
Well, my Lord always says it's always very helpful to know what's in the judge's mind.
Yes.
So I stand by that, of course. Anyway, we say that despite what my learned friend said, we don't, I'm afraid, accept that they've done everything they can to plead their case.
Is this point 3?
This is point 3, yes. So Mrs. Justice O'Farrell made it clear when she ordered the claimants to provide further particulars of causation that she did not expect them to rely solely on the recollection of individuals. That's a quote from paragraph 46 of her judgment, Supplemental Bundle, Volume 1, Tab 4, page 46. I'll come back to that. But we say at that stage, there were a number of sources of information that the claimants could have used to plead their case, including the websites. My Lords knows there's the SPDC website, there's the NOSDRA website. As my learned friend noted yesterday, Mr. William noted yesterday, we've never had evidence explaining which websites they checked for oil records and when. And we know, because that's what leads to the additional spills being pleaded, that they didn't initially, even though on the evidence, as we say, that information was available, or at least some of it was available, they didn't plead those additional spills at that time. Secondly, NOSDRA. The claimants say in their evidence that they received what is described as internal NOSDRA data in June 2023. Well, my Lords, it was presumably always open to them to obtain this information, but the claimants have not explained why this was not done earlier. Now, the statement that I've made actually comes from a statement which is not before the court, from Miss Modi, whose name my Lords have seen, in a 5th witness statement, but it's not part of the court bundle. Satellite imagery. Now, satellite imagery is publicly available in Nigeria. The claimants have never said whether they obtained satellite imagery to plead their case properly. And if they didn't do so, why not? But I do note that the claimants indicated in their original pleadings that they had considered satellite imagery. I give the reference, I'm not sure it's necessary to stand it up, but happy to do so if your lordships want. It's Core Bundle 1, tab 26, page 404. And secondly, Mr. Renshaw, in his 7th witness statement, which my Lords were looking at earlier today, noted that, and I quote from paragraph 104, it's at page 591 of volume 2, tab 28, he says, satellite imagery of Bille Kingdom appears to show areas of mangrove degradation, and notes that clearly this will be a matter for expert evidence. So, plainly, satellite imagery was known to them, and they looked at it for some purposes. Mr. Renshaw also notes, paragraph 118, at page 598 of that same statement, he says, and I'm quoting, it's anticipated that satellite imagery and remote sensing analysis will be particularly important for establishing the cause of the damage to mangrove habitats in the Bille claims. That plainly was information that they could have used to plead further about the causes of loss alleged. Then there's the JIV reports. Now, I do need to say something about the JIV reports in the light of the way that they've been dismissed out of hand. And I'm going to ask my Lords to look, please, at our defence, which sets this out. That's Core Bundle 2, tab 34, page 722.
Did I hear you say 722?
You did, my Lord.
Thank you.
So that paragraph, and it's subparagraph B of paragraph 51, explains the procedure and structure of a JIV report. And I think you can pick it up really the sentence which starts in 2006. In 2006, NOSDRA, National Oil Spill Detection and Response Agency, was established as the lead government agency for all matters relating to oil spill response in Nigeria. Under the NOSDRA Act 2006, NOSDRA must be notified of all oil spills within 24 hours of their occurrence. It's a statutory obligation to report them. A joint investigation visit will then take place in relation to the spill. The objectives of the JIV process are to determine and document a factual and unbiased view of the causes, impact and extent of an oil spill. The JIV process has been regulated in Nigeria since 2002, pursuant to the EGASPIN. Those are regulations of which my lords have heard some mention. In 2011, the JIV process, including the specific information to be reported in relation to each spill, was formalised under the Oil Recovery, Clean-up, Remediation and Damage Assessment Regulations 2011. So there's a regulatory framework in relation to it. And the important point I wanted to underline is how is it carried out? That's then set out. Each joint investigation report is carried out by a joint investigation team, which is made up of the regulatory agencies, NOSDRA, or the Department of Petroleum Resources, or the State Ministry of Environment, and the operating oil company, and representatives of the affected community and security operatives. The result of the JIV is recorded in a JIV report. The JIV report provides an overview of each particular spill, including its cause, scale and effects. It's intended to be signed by all parties present at the JV, and I'll just show my lords in a moment just an example or two of JIVs which have been signed, including by the representatives of the community, i.e. local residents. Paragraph C, once a spill has been identified and assessed via the JIV process, the relevant operator must take steps to remediate the spill if required to do so under the relevant legislation. Important point, my lord, because it's a defence if we can show that we did remediate a particular spill. One of the reasons why we need to know what spills are alleged.
Well, a defence to statutory liability.
Yes, and therefore actually to any liability in relation to it, because Mr. Justice Aikenhead held that the statutory liability was really exhaustive of the liability, at least so far as the operator is concerned. But be that as it may, it's not really an issue in these proceedings at the moment. NOSDRA, we go on to say, oversees the remediation process and will, after it's confirmed remediation via a site inspection testing, provide a remediation certificate confirming the same. And I'll show my lords where we plead to individual spills, noting where there is a certificate of remediation. My lord may have seen that already. We note that JIV reports are signed by at least one of the regulators, as well as the community representative that attended the JIV. And we note that certain of the named claimants in the Bille individual claim form part of JITs and signed JIV reports in respect of 6 of the 10 incidents referred to by the claimants. For example, Mr. Ofori signed the report for 4 incidents. Mr. Kamuel signed the JIV report for 1 incident, number given, and Mr. Ogonga signed the JIV report for 1 incident, number given. So, I want to take my lords also to Bundle 2, tab 4, supplemental Bundle 2, tab 42, on page 740. Because here, as I'm making good of my threat, I'm afraid, here's an example, a couple of examples, just so my lords just sort of see the sort of thing that it is. Supplemental Bundle 2, tab 42, page 740.
Okay, sorry. Those numbers don't work for me.
Page
Supplemental bundle too.
Supplemental Bundle.
Yes.
My fault.
No, it's mine.
Are you leaving your pleading now? Are you coming back to it in a minute?
I beg my lord.
Are you coming back to your pleading? In a
Not
minute?
at the moment, no.
Oh, okay.
That can be put away if that helps. Inevitably, I then turn to it straight
Okay.
away, but one always does.
Thank you very much. So, and it's tab 42, but page what?
740.
Thank you so much.
Now, this is one of the JIV reports relating to Bille. And so one can see just the form of report. It's got numbers, got dates, it's got the name of the nearest community at item 4. It's got information about the incident. So we can see there the date of the incident, the start date, time of the investigation, that's given. So the incident was said to have been 14th of August, and the investigation takes place about 9 days after that. It ends in September 2006. Actual investigation date for this was 2 days. And then the description of the environment, and importantly at C, description of the leak point. And there are lots of options, but in this case, the leak point is a hacksaw cut. That leads then to the next item, item F. The incident is caused by
Sabotage.
theft, well, third-party interference, sabotage, actually not theft, is ticked. And then that is, if one goes more, over the next page, one can see more details. And boxes are filled in with some details one can see on the bottom of the second page, actually showing a picture of the cut to the pipe with measurements attached. Stick together the pages, okay. Then some details of the coordinates taken. Then some information about the area impacted, the volume of oil, the amount of the infiltrated oil in the soil, estimated volume, some further information on the next page, and I wanted then to take my lords to, well, the net estimated spilled volume is at the bottom of page 745 on this one, and then there's a box to fill who has actually signed the reports. And what has been ticked here is it was signed by NOSDRA and the State Ministry, by Shell, but also importantly by the host community. That's the very first box. And the question is, which is ticked with a positive affirmative tick, the signatories agree with the reported findings. And if we go to the next page, we see some more details, an overview sketch of the site, and we actually see on the next page, we actually see the signatures that are there.
How many of these joint investigation reports have been disclosed in the Bille litigation?
I'll have to ask from that. For all the reported spills.
Yeah, but how many?
Oh. 99. For Bille it's 95. For Bille it's 95. For Agali it's 200. More than 200.
Let's concentrate on Bille.
And is that the sum total of JIVs in Shell's possession for 2011 to 2013 for Bille?
Yes. Yes.
At all?
At all.
At all. There are no other JIVs in Shell's possession relating to spills, any spills in Bille 2011 to 2013.
No, because they're all reported.
Yes, yes. And that's because, yes, I'm being told it's because there's a statutory obligation to report the spill. Incidentally, often the spill will be notified by a member of the community because they will see it bubbling up or whatever it may be. But yes, then there's an obligation to do that. It's then reported. It has to be reported to NOSDRA. It goes, Shell reports it on its website, and it's reported by NOSDRA on its website. There's one important point which my lords may have picked up already in relation to the NOSDRA reports. They, need to get this the right way around, they identify incidents, not just spills. So there may be incidents identified which actually were not spilled, result in oil being spilled, but it's still an incident that would require to be disclosed, reported. And that's one of the reasons that there's a discrepancy, your lordships will have seen, between what NOSDRA report and what Shell report on their own website. It's said, my lords will recall, it's said by my learned friends that one of the criticisms of Shell is that its reporting and its what it says the spills were is that the numbers in the Shell reporting don't correspond exactly to those in the NOSDRA reporting. We say that is because they're reporting different things. NOSDRA reports incidents, which would include, so it'll include incidents, spills, but also non-leaking incidents will be reported by NOSDRA, but they won't be reported on the Shell database.
And I'm sorry, just to sort of trying to be clear in my own mind. You've told us that all JIVs in Shell's possession for in 2011 to 2013 have been disclosed.
Yes.
Fine. Lots of nodding of heads behind you.
Then it must be right. That's all right. Yeah.
Does that mean that all documents in Shell's possession relating to spills, or does that mean that there are no documents in Shell's possession relating to spills other than the 95?
No, I want to just say I want to spend a few moments on what we have actually disclosed.
Okay.
I can't do it quite in answer to that question.
All right, but if I can remember the question, I may come back to it.
We'll make sure we answer it at that point in any event.
Yep.
So the point I wanted to make really is a lot of criticism has been made of the JIV reports. Your Lordship will see the process. Your Lordship will see that the regulator, perhaps the police, but certainly representatives of the community will be involved, generally speaking, will sign, if they agree with the report, what has happened and what the event is. So the rather generalised, unparticularised criticisms of the JRA report, which the claimants rely upon, which come from Amnesty, we don't accept that is a fair criticism of the JIV reports. We respectfully submit, we believe that they are the best evidence of what took place. They are the only contemporaneous evidence of what took place. And proof of that is given to some extent by the fact that despite the fact that we have disclosed these, there has not been a single challenge from the claimants to a single piece of information in any of the JIV reports in these proceedings. They make these generalised allegations about the JIV reports based on the Amnesty report and one or two other things, but they haven't actually pointed to any specific element of information in the JIV reports which they can show is false, wrong, or unreliable. So they haven't, for example, in all the years since the reports were provided, all the time since the reports were provided, they haven't alleged that any particular JIV report underreported the volume of oil spilled from a particular spill.
Forgive me, when were the reports provided?
Reports 2022. And the claimants haven't explained whether they accept that the information contained in the JIV reports, which were signed by individual claimants in these proceedings, is accurate. i.e., where individual claimants actually attended, and we've pointed some examples where they did, alongside the regulator and others, and signed the report confirming the accuracy of the contents. Instead, they persist in referring to the Amnesty report that makes extremely generalised criticisms of the JIV report. We respectfully suggest that they are very valuable, the only contemporaneous evidence of what actually occurred, what caused the spill, and what volume of oil was spilled as a result. So they cannot be dismissed in the way that the claimants seek to do.
You don't prove them negative, do they? And as I understand it, part of the claimant's case is that some spillages occur which are not the subject of JIV.
Plainly, the JIV reports relate to spills which are reported. I accept that. So they wouldn't do anything else. I mean, that would then depend upon the reliability of the process for reporting and all of that.
Yes.
But in terms of what is there, it just can't be dismissed. The JIV reports are useless, which is paraphrasing, but not too much what my learned friend was saying to your lordship.
And on your explanation, if there's some illegal bunkering, should that feature in the JIV?
No, that wouldn't.
No?
Not necessarily.
Well,
if there was
the damage to the pipeline would, if there was damage to the pipeline.
in a JIV.
In a JIV, yes, it would.
Therefore, it follows that any spill, whether it be because of failure of the pipeline or sabotage with a view to illegal bunkering, should be recorded in the JIV.
Well, you have to consider the different options in relation to how this can happen. If there's damage to the pipeline, if the pipeline is damaged in order to extract oil, that should be
a JIV.
That should be a JIV. I'm not getting the nods from behind that I was saying.
No, you're getting, there's a slight mix coming through.
There is a mix, my lord, so I don't want to...
Just to turn around and have a whisper if you don't want to rely on hand signals.
We'll get back to him.
They prefer to check it and allow me to get back to your lordship.
I mean, the form anticipates, under incident information, that one of the descriptions of the leak points may be crude oil theft, illegal bunkering,
Yes.
which rather suggests that the JIV reports are meant to capture those incidents, doesn't it?
It does suggest that, my lord, but I'm reluctant
Fair
to
enough.
confirm that's what they always do.
Fair enough.
And I mean, my lords will understand that some of the illegal bunkering, the theft, takes place away from the pipeline. Some of it actually takes place at the pipeline. I mean, they get the oil out and they put on a branch line or something like that, or they get it out and they put it on barges. It may be refined there, it's possible. Very likely it's refined somewhere else. And of course, our case is that an enormous amount of the pollution that comes is from the remnants, the waste from the illegal refining that takes place. Artisanal refining, which I always think is very...
And that would work both ways. You may get a theft of oil in Bille, which is then refined illegally elsewhere,
Yes.
or you may get a theft of oil elsewhere, which is illegally refined in Bille.
That seems logical to me.
Yeah, there's a bit of nodding going on.
And then it must be, yes, I'm glad. In other words, you can see that.
Yeah.
It's maybe a very elementary question, but what's the difference between a leak and a spill? The document uses leak in some points and spill in the other.
Well, I can guess what it is, but I'm not sure how accurate it would be. That it would be to do with the volume. A leak suggests a rather lesser amount, but again, let's just add that to the list of the homework so we can.
That was this was overarching point 3.
Yes, I haven't quite finished with that.
Right. Okay.
No, I'm on the sources of information, and I've been including the JIV reports, contrary to my learned friend's submission. But I also want to deal with expert analysis. My lords, it'll be very familiar to your lordships that it's standard practice in any technical claim to obtain expert assistance in order to plead the case properly at the outset. It may be essential to do that. It may not be possible to plead it without that. But it's commonplace to do that. And in a case such as this, where causation is complex, that's the bare minimum one could do. Instruct an expert to consider the available source of information, provide at least a plausible theory on causation. Where could it be coming from? My Lord Justice Stuart-Smith, who had familiarity with the Bonga claims, will know that that's something that did happen. People looking at where oil may have migrated from and by what mechanisms. And this was put to Mr. Hermer by Mrs. Justice May at the hearing in July 2003. And I want to show my lords what was said about that. The reference to it is Supplemental Bundle 1, tab 12, page 220. To understand it, one needs to pick up the transcript. It's a transcript of July 2023. Mrs. Justice May, on page 72, which is page 219 of the bundle, is asking Mr. Hermer about sources of information. He's referred to satellite imagery in the column above, internal page 71. And then she comes back to this at line 6. Just to be clear, you have individual claimants saying, I can't identify what the specific spills were that have caused my loss, but I know that my mangrove habitat, the places where I fish, have been polluted during the period. And you tell me that notwithstanding that your claimants for good cause can't identify specific events, nevertheless your case is based on specific events, and you will identify these events. It's not a global claim, it's an events claim, a specific event claim. And although your claimants can't now, for good reason, except for a few, identify specific events, you'll be able to do that because your experts will look at satellite images and other evidence, overflights, and you'll be able to say whether this was a spill and so forth. And Mr. Hermer said yes. That's at line 23. And Mrs. Justice May rightly asked in our submission, well, why can't you do that now? You've satellite imagery now. Why haven't you had experts on this now? Mr. Hermer's, Mr. Renshaw refers to, we have, but absent disclosure, we're not able to get to a point at which we can identify it. And this discussion goes on, and at the bottom of page 74, internal page 74, Mrs. Justice May asks, you don't need disclosure to understand the water basin in which Bille was, to map the water courses, including measurements of creeks. And Mr. Hermer said there were two answers to that. As I hope Mr. Renshaw may explain, it's a multidisciplinary approach. Mrs. Justice may understand that. Seems to me many of the disciplines have already been at work, perhaps they already have. And Mr. Hermer, understandably, didn't want to waive privilege. But then Mr. Hermer said this, my lady will appreciate this. Obviously, in a case such as this, steps are being taken with experts, but there is also reality in this case, which is that absent orders from court approving expert disciplines, and in a case in which this is being brought under a CFA on behalf of claimants who are effectively most of them penniless, and to which it's being brought by an obviously well-known but medium-sized law firm, it's not reasonable to expect that effectively hundreds of thousands of pounds about permission of the court to instruct experts to work at detailed work should be expended at this stage prior to admission. That's a very important observation, statement by Mr. Hermer at that stage. And in fact, we came back to it because I picked up on it.
What follows is important. He's drawing the distinction between carrying out detailed work and the fact that they have, as was confirmed by one of the witness statements we looked at this morning, had the assistance of experts.
Well, I understood him actually saying we haven't done it because we don't want, because of the financial side, the financial implications. And indeed, Mrs. Justice May is saying, look, you want to bring a claim, you're saying that it partly depends, what your claim is depends on having some expert assistance, well, why don't you get it? And to which Mr. Herm is saying, well, no. And I put that, when I came to deal with this, and it's on page 228, the bottom half of the page, line 5, internal page 106. So Mr. Justice May said, as I understand Mr. Hermer's submission, he's saying it's not impractical, we just can't do it. That's a reference to it being impracticable, to be more specific. She's taking his position to be, it's not that it's impractical, it's just we can't do it yet. And I interjected,
where are you, sir?
I'm sorry, internal page 106, left-hand side,
yep.
On page 228 of the bundle.
Yep. Thank you.
And I said, well, what he actually said is they don't want to do it. And Mrs. Justice May agreed with me. That's what he was saying, which is a choice that's been made, and that was a revelation I suggested, though some might have suspected it, that he made openly today. And the question is whether or not it's legitimate to make that decision, not therefore to give the defendant the case that they have to meet with sufficient particularity that they need, and then say, well, that's all right, we're going to go to trial, and we'll see what happens when we get there.
That comes back to something I think I said a couple of days ago about the difficulty I think I've used the phrase claimants putting their head above the parapet before the case is in apple pie order. It's always a tension, particularly now claims have been funded effectively by the lawyers.
Well, that may be so. The point is here. What I'm saying is, it's not a case. That's what I took from what Mr. Herman said. It's not a case that they can't do it. It's they choose not to do it, and they choose not to do it if my lord is right, because the lawyers don't want to pay for it. Even though you've been told that lots and lots of money was spent on filling out the schedules, but they didn't include the basic idea of getting experts to come and say, look, this is where our clients have suffered damage. Where do you think it comes from? Here's a map, we can get a map, we've got some overflight, you can have a look at it, where do you think it comes from? And then put that forward, but they've never done that. If they've done it, they've certainly not told us.
That's, with respect, that's completely unrealistic. If the information you've given us is right, and the available information to them from public sources would have been 95 JIVs, the suggestion that this number of claimants, on that basis, together with satellite imagery, could identify where all their spills came from sounds, to my mind, completely unrealistic.
Well, my lord, I hear, of course, forgive me, of course I understand what my lord's putting to me. It's not all the spills, it's the spills on which they rely. An individual claimant will know where he or she suffered damage.
If this case goes forward,
Yes.
it's very technical. It's very technical because you've got claimants, effectively it's got to be reverse engineered. You've got claimants who say my land has suffered oil pollution.
Yes.
And then you've got to start working, and most of them can't say, and I saw oil gushing from a pipe and it came down the hill and sploshed my land and that's it. Mm. If any claimant, perhaps the 5 Bille claimants who are excluded are different. But otherwise, you've got to reverse engineer it and say, where did it come from? With limited information. It may be that there were only 91 spills in 2 years. Possible. Sounds a bit unlikely, given what we know about what was going on in Nigeria. Yeah, I'm sorry, at the moment, I don't want to sort of argue with you, but at the moment, I remain of the view that submission you made is unrealistic.
Well, my lord, I'm obviously sorry to hear that. I maintain the submission. I maintain the submission that they had more information. They could have done more than they have done, and I've been showing your lordship the source of information that they had.
Well, at the moment, we're still on the overarching points,
yes,
which are going to lead to why you say a global claims declaration or order was appropriate.
Yes.
So
I've put another sticker on.
We note that you are saying, and it's developed considerably in the skeleton argument, there is lots more that the claimant's lawyers could have done. Right.
Yes.
Tell us what the fourth overarching point is, and then let's get on to global claims.
I've got a couple of pages before I get to the fourth overarching point, I'm afraid. Because I just want to draw attention to the specific disclosure which the claimants applied for. And I'm going to give my lords the reference. They may not want to turn it up. Modi 6, paragraph 9, that's Supplemental Bundle, volume 3, tab 59.
Sorry, Modi 6.
Modi 6, para 9,
yeah.
That's Supplemental 3, tab 59, that's page 856. The claimants applied for the specific disclosure, specifically, and I quote, in order to make meaningful progress with expert evidence, and in particular to make progress towards identifying which spills caused damage to which areas. That was the application which came before Mrs. Justice May at the CMC in December 2023. And almost all of the specific disclosure sought was granted.
Paragraph? What paragraph?
That's paragraph 9 of Modi.
Thank you.
Page 856. Now, this really now falls into Mr. Willen's side of the case, but the material disclosed as a result of that, all available satellite imagery over Bille, photographs taken during daily overflight helicopter surveillance in 2012 to 2014, documents, photographs and video footage surrounding the JIV and remediation exercises of all known spills in Bille in 2011-2013, a detailed environmental baseline study which covered Bille, laboratory analysis of soil and water samples, environmental monitoring documents, annual pipeline integrity reports, well maintenance records, and many more. Now, the point I'm making is that this material has been provided, and although my learned friend today referred to some of that material, they've done nothing to change the pleading of which spills are relied upon. They don't appear to engage with this material, even though they said, and again I want to reference, in Modi 6, this was in order to enable, to make meaningful progress to identifying the spills. What is happening, and this is the dilemma that this puts the defendants in. The defendants are entitled to a fair trial and a fair shot too. My learned friend said the claimants need all the material. Got that in the transcript day 1, page 155. It's a maximalist approach to what information they want, standard discovery on everything. And this is the dichotomy between obviously giving the plaintiffs, the claimants, a fair opportunity to present their case, but putting the defendants in the position that they don't know what it is they have to meet. And I'll show my lords this, because this is the next point, which is that without that information, the defendants cannot investigate and present their case. So that's the fourth overarching point, which I finally, my lord, get to. The fairness issues. I mean, there are the problems. It's really the general point that the problems with what the claimants are proposing. First, the fairness issues that their approach gives rise to, which effectively precludes the defendants from raising individual defences in respect to the pleaded and asserted oil spills. And I'll show my lord why I say that's so. Now, our response is to address individual spills. That's what Mr. Willett told my lords yesterday. It requires us to address the individual spills. And there are different issues in relation to liability and different defences which arise, which need to be investigated. So each spill takes place at a different place, at a different time, caused by something different, and released a different amount of oil and affected different people. There may be some similarities, of course, in certain cases. But all of those facts are essential when considering the individual defences, including the TPI defence. The TPI defence is to know where the spill was. Was there a third party who interfered with it? One needs to investigate the spill to see that. But even if they get to the ability to be able to plead their case of saying, well, you failed to protect the pipeline, so you're still responsible, even though it was a third party interference. Well, we need to know, where is it we failed to protect the pipeline? Is that because that's a fault-based claim, is that a reasonable thing to say? We would need to investigate. So we need to know where it is. Where's the bit of the pipeline which apparently was affected, which we should have protected? Critically, and I made this point to my lords before, it is a defence to the statutory claim that we have remediated a particular spill. So we need to know where the spill is so we can investigate whether it was remediated. And I mentioned the certificates that the Nigerian regulators provide. And we don't know, on the basis of the current pleading and the current proposal, which spills would be addressed on a trial of lead claims identified in the way my learned friend described this morning, because the individual claimants have failed to identify which claims they are relying on. Not all claims, but which are the claims that they're relying on. They rely instead on an open-ended basis. Each claimant claims in relation to all spills in Bille, with the exception of the 5 Bille claimants who limit themselves to a particular spill. each claimant claims in relation to all spills. I'm going to take my lordships to one document that is relevant here, but without specifying the causal link between each spill and the alleged damage that they suffered. The document I want to take my lords to is the voluntary particulars of claim. They're in bundle C1, tab 28, page 482. Core bundle. Core bundle 1, tab 28, page 482. Now, this was served in January 2023. And my lords see in paragraph 2 that except insofar as any claimant in their schedule of information says their claim is limited in scope to one of them.
Read it out.
I'm sorry?
You don't need to read it out. We can read it.
Well, then, my lords, will my lords also please read? I was going to invite my lords to look at paragraph 3
Yes.
and 5.
Yes.
I always read it all, but you've seen some of this already. But the point I want to emphasise is, with the exception of those who in their schedules of information limit themselves to a particular spill, all of the claimants rely upon all spills. So it doesn't matter that they're at the opposite end of the area of Bille, no particular connection in terms of oil flows, they rely upon everything. So this doesn't limit the claims at all.
Well, the real substance of what you've read us is they don't know which spill is which.
Well,
They can't attribute their damage to a particular spill.
well, that's what they say. Now, Your Lordship,
So they leave the door open by saying it's still the claim we originally pleaded.
well, what they're doing is that, and by this stage, some of the discussion has obviously taken place before Mr. Justice O'Farrell and Mr. Justice May. They're saying, well, we're going to rely upon all spills, and that means it's open-ended. That's the significance of 5. And at the time that 5 was pleaded, it identifies, of course, the 10 spills that had been originally pleaded, but it also refers to the unpublished spills, which really means all the other ones that are now.
Yes. Well, the first appeal.
So that's the first issue. Secondly, they propose a trial of reclaims in circumstances where we don't understand how the decision in relation to those claims would be extrapolated to the rest of the claimant cohort. Unless claimants have said which spills they rely upon, how do you know if a decision that actually no, the defendants are not responsible for that spill applies to anyone else, because we don't know which spills they've relied on? We also know, and I'm just picking up, Mr. Willan will take up the baton on this more substantially. My lords will be well aware of the reference to the particular fishing areas which a number of claimants use, and that's been particularly relied upon. But they are not, let me put it this way. Yesterday, Mr. Willan took you to schedules of information that show that both of the individuals of whom one's got, you saw the particulars, don't limit themselves to those sites in any event. They don't limit themselves to the sites included in the claimant's 12 main fishing sites. So one sees from page 763, and Mr. Willan can take this through. So, let me just give the references. Eunice Okile, this is at page 763.
Or supplementary.
Supplementary bundle 2, tab 55. She fished at one of the 12 main fishing sites, but also at one other site which is not on the map. That appears from page 763.
Is that Namasibi?
Yes, Namasibi. And similarly, Ethel Carey fished at one of the 12 main fishing sites, but also at 2 other sites not on the claimant's map. That's Darturu and Gogo Pokeri. That's page 767. So the resolution of claims in respect of 12 fishing sites won't even resolve all of the claims by those particular claimants. Now, I understand that there are, in fact, many other fishing sites not on the map in respect of which any findings from the lead claimant's trial could not be extrapolated. There needs to be a mechanism to extrapolate decisions in relation to lead claimants to other claimants. May not be every single one, but there needs to be something there that takes it further than is being proposed. And that's a serious deficiency in what's being proposed.
But the decision is there shouldn't be lead claimants at all. It
Yes.
should be single claim with 2,000 claimants, and it's all or nothing.
Well, the decision is that it can't be lead claimants because there isn't enough information provided as to what the claims are to be able sufficiently to identify the individual, the lead claimants, precisely because you need to know who is representative of the wider cohort. And without the detail of what everyone is claiming, you can't do that. And that's the reasoning, both from Mrs. Justice O'Farrell and Mrs. Justice May. If you want to identify representative claimants, you need to know what's the constituency of which they're said to be representative. Not every single detail, perhaps, but you do need to know, are these claimants who are claiming in relation to this spill, or are they claiming in relation to that spill? And it's exacerbated by the fact that some individuals have indicated that their claims are not even limited to the locations which they've set out in their schedules of information. Now, I'm just going to tell my lords this, because I anticipate you don't really want to see the documents, but Mrs. Dapper, who's referred to, my lords will recall her witness statement, she says that she suffered damage in numerous different locations, not previously referred to in her schedule of information. We pointed this out to the claimants in a letter dated 30th of July, invited the claimants to confirm that each claimant limited their claims to those in the schedule, and the claimant stated they were unable to provide that confirmation. That's a letter dated 23rd of July 2023. So, if, and here's the end result of that, the trial of lead claims proposed by the claimants would not be able to deal with all the claims, and there's a clear risk that new claims will keep appearing, given the open-ended nature of the claims.
Can I just offer an alternative point of view?
Please, my lord.
You've indicated the difficulties in a case like Mrs. Carey, if it's Mrs. Carey, Ethel Carey.
Yes.
To me, it just looks like a defendant's dream lead case. She can't. She's in 3 places. Item 10. She can't identify. She says she can't identify. She doesn't give a date. That's your number 1 case.
Well,
And the claimant's number 1 case is the one where the man saw the leak coming straight out of the pipe down the hill and ruining his thing, if such a case exists.
my lord, I understand what my lord's putting. The problem is, if you've got lead claimants, you want to have them representative of a greater class, so that if you get a decision one way or another on the lead claimant, it follows through to the rest of the class. Otherwise, there's no real point doing it.
Well, of course, but the 2,000 cases will not be on identical facts. So I mean, I've never done this, but surely what you do is you take people who fished in each or at least most of the 12 sites which are said to represent 94% of the spills or 94% of the claimants, and you, if you know, you take them at various times, and you try those cases, and that should give you the answer to most of what's left.
But you need to have, on top of that, you need to have a commitment that that will decide other cases.
You can't have a commitment.
Well, my lord.
No, what you do is you set up it's standard practice. You set up a group. You hope that will clear away a lot of the cases. Some cases it's very successful. You get a decision on lead cases and the whole litigation goes. Some cases it's less. But at least you create a workable structure which may at least clear out half the claims.
Just consider, my lord, if I may, consider this. In this case, we have quite a number of spills that are, that's just the ones that are now pleaded, number of spills that are alleged. So you have a trial of a lead claimant, and it appears that that lead claimant is really complaining about spills 2, 3 and 4 in that corner of the field. Mm-hmm. A decision is reached, yes or no to that. That will not tell you anything about anyone who then says they're relying upon different spills. I mean, there are some general questions like, are we liable for third party for illegal refining? But that's going to be determined by the preliminary issue.
Yes.
Right. That's an important event.
But the problem you indicate is solved, isn't it, if you have enough lead claimants to cover all of the main areas which are being fished, because then there will be a decision on whether you are responsible for pollution in that area or not, which, whether or not formally binding, will in practice resolve claims of other claimants.
We deal with this, and Mr. Willan will deal in more detail with the particular main fishing areas, because he has the detail more at his fingertips than I do. But we say, if I can direct my lords to paragraph 125 of our skeleton argument, but I don't have the reference to the page number.
I think it's page 238.
Thank you, my lord.
125.
Yes, because that's what we set up. Paragraph 125.
There is also a real risk of evasion.
Yes, we call it pivot elsewhere as well. That is to say that the risk that some claimant will be able to shift their case in the light of the decisions which have been made, precisely because they haven't tied themselves to any spill or spills prior to the date of that decision. So they could all change their position. Why should the defendants be at risk of that when what we're asking for is a better identification of what are the spills which are relied upon? And with the help of the information which is available and some expert evidence, the claimants ought to be able to do that. We're concerned about a movable feast in which there's a serious risk that any findings in respect of lead claimants would simply be ignored by the other claimants on the basis that they've not limited their claims to the spills in issue in the way that the lead claimant has.
But I thought the scheme of group litigation is that the managing judge identifies the lead claimants put forward by the parties. There's a trial of the lead claims. At the end of the day, if other non-lead claimants say, well, the fact that X, Y, and Z all lost doesn't affect me because I lived half a mile away and spills on a different date, the judge may say, sorry, this is not credible, or the defendants apply to strike it out. If the lead claimants are properly selected and their cases are tried in some detail, then that is likely to put an end, depending on the result, to either other claimants who want to come forward with different cases, or for that matter, the defendants trying to resist other cases.
In my respectful submission, not unless there is an identification by the other claimants of what they're actually relying on. If they are open-ended as to what they're relying on, then they're not really constrained at all. And the managing judge, and it's also Mrs. Justice May, who's seen the significance here, the managing judge cannot say to people who haven't in any way limited themselves to spill 3, well, because we've decided that Shell are not liable to spill 3, that means your claim is gone. And we want a better system than one which is just open-ended in this way. And there's also the question of the disclosure which we're expected to give on this approach, which Mr. Willen, I think, will develop.
But isn't it rather unrealistic to think that lawyers or funders who have invested millions of pounds in a major trial with lead claimants covering all the areas which are likely to be an issue and who lose are going to stump up to do it all again?
Well, my lord, if they've lost out, they may absolutely want to have another go, because then they can recoup some of their money. So I can't answer that, my lord.
Can I ask what I mean, there is a lot of firepower in this court at the moment and a lot of experience of these sorts of actions.
Yes, my lord.
Speaking entirely for myself, I'm not aware of any case in my experience or knowledge where the theoretical risk that you've just identified of people coming back for a second bite has actually really come home to bite people. Maybe that Dr. Blake is giving you something.
No.
Yes. I was going to make this point, but honestly. This is a very unusual case. There's no case that's quite like this, because we've got over 200 events which are identified. If you look at the other claims which have come, and we've looked at this, you get 1 or 2 spills. In the Nigerian cases, 1 or 2 spills. So it's much, much easier. In Bodo, there was 2 spills. In Vedanta, it's spills from 1 operation.
But it's not just limited to oil cases.
No.
I have direct experience of trying one case where 4 lead cases, none of which were directly extractable because they were all to do with different parts of the pipeline, led to the settlement of the entire action. And that's the objective. And it may be settlement as in a sense of that the claimants all withdraw, or it may be settlement that the defendant says, well, there's enough in this to show that we're at real risk, it's time to come to the table, or whatever. I don't think, while I'm prepared to accept what you say about this case being unusual, the issues that it raises are not.
My lord.
About how to push this case forward. Otherwise, as Ms. Day says, we're in a catch-22.
We don't accept that.
Okay.
And we will come on to develop why we don't accept that.
All right, can we get on to the global claim?
Yes. Can I just make this general point before I do, which is the risk, the concern, if, on my learned friend's case, claimants can bring a mass claim in respect of unspecified events over a wide area, over many years, without giving details of the claim, without particularising the specific events on which they rely and how those events are said to have caused them damage, they can then say the defendants must disclose everything relating to that broad area over that broad period of time so they can see if they have a claim. That is an unreasonable position to put a defendant in. And that's one of the things, and you've heard it today, that's exactly what the claimants want to do. We say, And they've had one specific disclosure application already, and it's produced quite a lot of material. We think a lot that they could use to advance their claims. If, contrary to our view, actually what they've had isn't enough, they should not be asking for standard disclosure, i.e. everything in relation to all these events over the period of time, 2011, 2013, and it's even worse in relation to Ogali, of course, because that's a much longer period. They should be making a further application for specific disclosure. But Mr. Willen will develop that. So I want to turn to global claim because my Lord has taken me to that particular water at least twice. To do that, I think it's important, respectfully, to understand how we got to the global claim, and that's the procedural history. I've made the point, first of all, about the... And I'll jump over that. The extent of the events claimed here compared with other cases. Now, the story actually starts 3 years ago when the lower court recognised the deficiencies in their statement of case in December 2021 when Mrs. Justice O'Farrell, who was the judge in charge of the proceedings at that time, first raised the global claim issue. I do, though, want to also note in doing this that the characterisation by the claimants that the delay that has taken place is all down to us is completely not right. How much my lords care about that's another matter.
Well, 5 years was spent on jurisdiction.
It was.
Yes.
And we won twice. We won at first instance, we won in the Court of Appeal. So it was not a frivolous attack.
But that is the system. Yes.
Well, it's the system, yes. Exactly, it's the system.
Yes.
It's the system. So the issue so the deficiencies were identified by Mrs. Justice O'Farrell. And then the amended particulars in July and August 2021 reiterated that the claimants were relying on every spill that occurred in and around Bille between 2011 and 2013. And that's paragraph 1 of the Bille Individual Points of Particulars of Claim, Core Bundle 1, tab 26, page 396, paragraph 23, no need to turn it up. And I mentioned in relation to Ogali, my lords haven't looked at this, but it's worthwhile just noting that's even broader, as I said, because they rely on all oil spills in or around Ogali since at least 1989, 35 years in other words, but without any limitation of time at all. That's paragraph 21 of the Ogali re-amended points of claim, Core Bundle 2, tab 31, page 577. There are 3 deficiencies. Failure to identify all the relevant events, failure to link each event to the particular damage allegedly caused, and failure to link allegations of negligence breach to particular events. Now, the only one that matters for global claim is deficiency 2. As my lords have seen, we filed defences in November 2021 which picked up on the inadequacy of the claims. And I don't need to take my lords to that again because they've seen that. That was then a key issue at the December 21 CMC. Prior to it, we filed a skeleton argument where we particularly drew attention to the lack of particularisation. The reference, again, I don't need to ask my lords to look at it, I think. Tab Supplemental Bundle 1, tab 2, page 18.
Let's have a look at it.
Well, my lords can read that for themselves.
Yes, you said there that the Bille and Ogali claims must be assessed on a spill-by-spill
Yes.
basis.
Yes, indeed. I'm going to make, I hope, that good. And because of that, we asked that the claimant should provide additional information. That's a spill-by-spill basis. That we couldn't even determine which legal regime applied to their claims on that basis. If I can take my lords to the transcript of the hearing in December 2021.
You give an extract from that at the bottom of page 3 of the skeleton, page 202 of the content.
Yes, because that's when, very true, that's when the concept of global claim first was raised. And it's perfectly right that it's Mrs. Justice O'Farrell who raised it, not us. But the point I want to make is we had been raising the point about the inadequacy of the pleading, the inadequacy of the particulars, and this is really a response, we say, to that. So, if I can, this is, my lords have seen it, but I think just very quickly look at it. A supplemental bundle tab, volume 1, tab 3, page 21. This is when she asks Mr. Herbert, it's tab 3. So, about halfway down the right-hand column, Mrs. Justice O'Farrell puts to Mr. Hermer, is this a global claim that you're putting, relying on each and every spillage as being a spillage which the defendant is responsible, which caused damage to claimant's land? Mr. Hermer, without hesitation, says that's right. She returned to the point on page 25, page 23 of the bundle, but page 25 internally. The question that she raises at line 9, is your claim in the Ogali matter, again, a global claim in that you simply rely on all spillages at the relevant time? You can't identify any specific spillage that was attributable to particular negligence, or you simply list all spillages that occurred and all contamination that occurred was the responsibility of the defendant legal. And Mr. Hermer confirms that. And then at internal page 26, line 12, after that discussion, she says, well, I think that confirms that it's a global claim with all of the difficulties that are brought by global claims. I understand it. Mr. Hermer, indeed, he says. I'm slightly surprised given what's then said about his knowledge about global claim afterwards, but we don't need to worry about that.
Well, you say that must be construed as a concession by Mr. Hermer that there will be no lead claims,
No.
will be dealt with according to.
No, my lord's assuming.
Can you point to any case in which the court has decided to put litigation on a global claim basis against the wishes of the claimant? Because all the ones we've shown were ones which were either building claims or cases related to the construction of a building, where the claimant, usually a contractor, is saying, please look at this overall and deal with it as a global claim and don't get into too much fine detail. And the judge says, well, if that's the way you want to do it, then it's all or nothing. But we weren't shown a case in which the defendant says you should treat this as all or nothing, and the claimant is made to do that despite the fact the claimant wasn't asking.
But that's the point about the choice, the binary choice. The claimant can say, look, I don't want to be treated as a global claim. I see what the difficulties are. but then declines to give the particulars which enables it to proceed on the basis of an events-based claim, using that terminology. Because they're not giving the particulars. They're not saying what all the spills are on which they rely. They're declining to do that. And if I'm right in my reading of what Mr. Hammer said, they're declining to do that as a deliberate decision.
Well, but this is a case with 2,000 claimants.
Yes.
It's not a case with one claim.
Yes.
So why does it follow that if claimant 1 in fishing area 1 fails, that claimant 700 in fishing area 12 fails as well?
That's not the way it works. It doesn't work that way. And if that's what my lords have taken as to what the global claim means, it's not. It's the individual claimant is relying on a number of, indeed on all the spills. It's not that if one of them fails, they all fail. It's if one claimant is claiming for alternative causes, and one of those that is causative is not the responsibility of the defendant, then his pleading has failed. He said you're responsible because it's either A, B, or C, and you're responsible for all of them. It then turns out he's not responsible for one of those, or it's D, for which he's not responsible. Then the claim fails.
Well, A, is that really what the judges below were talking about? My reaction at the moment is no.
Well, I don't know why.
But secondly, if you get to that point, if you follow this line, it's still open to a defendant or claimant to say, well, okay, one of the 5 causes may not be down to you, but what you've done is an effective cause, either on the basis of material contribution or otherwise.
Yes, I'm not dealing with, I'm not going to deal with material cause contribution unless your lordships want me to.
We have to have clarity, because we're being asked to set aside a declaration.
Yes, I entirely accept that. What Mr. Justice May said, and your lordships would have seen this, is saying this is material contribution doesn't actually answer the question. Because whether it's material contribution or but for, you still have to identify what are the events that you are relying on. And that's our fundamental point.
Following up my lord's question about whether there is any case where a court has imposed a global claim on a claimant, I noticed when you took us to the transcript of the July 2023 hearing,
yes,
at Supplemental Bundle 1, tab 12, page 228, internal page 107, that Mrs. Justice May said, and this is after the voluntary particulars of claim, that there's no prospect of my making a declaration that it is a global claim because they don't want that. They stand or fall on an events-based claim as it is at that moment.
yes.
But then 6 months later, that's exactly what she did. She did make a
and that's why I was...
and nothing had changed in that they still didn't want it and had made clear in their pleading that that was not how they wanted to put the case. So
yes.
So what had changed?
But they didn't. Well, what they don't want to put the case on that basis, but they don't want to give further particulars or say they can't, but we don't accept that. But in relation to the events, so you can either have an events-based claim, or you can have a global. You can. I'm saying this badly, and I want to start that little answer again. When it comes to pleading, there are certain things that need to be pleaded. And one of those is the event which you say caused your loss or your whatever else you're claiming for. If you don't do that, if you don't plead all those elements, the essential elements of the cause of action, you are liable to be struck out. That's the first point. But there is an escape route. And that's what the global claim is. It says you can, even though you can't identify what caused your loss, whether it was event A, B, or C, you can plead compendiously or globally all those events, A, B, or C, as long as they're all the responsibility of the defendant. And that's what the global claim does. And whether it starts in Scotland or it starts in construction doesn't really matter. It's just a logical following from allowing you to plead alternative events without specifying which one it is and going to trial on that basis. And so the global claim is no more than that. It's a label that describes that. And what the judges have been saying, and I invite my lords to read the judgments and we'll see this, they're saying, well, you don't want to, or you don't want, or you can't, it doesn't matter which, but if you can't, then what you're doing is relying on all of the claim, all of the events, all of them, without identifying which. That means it's a global claim. You can do that, but you suffer a risk. You're a risk, and that is it will turn out that it's not one of the events for which the defendant is responsible. Now, of course, that will then encourage and incentivize the claimant to be more specific. And one suspects, though they didn't say this, that both Mrs. Justice Farrell and Mrs. Justice May were trying to encourage the claimants actually to be more specific. She thought they probably could be. They thought they probably could be, but were not doing it. But this is a way of encouraging that. And we respectfully think that's a good idea, because we don't want claims against us which are so unparticularised as this, because it puts us into great difficulties. We have to give all this disclosure according to the claimants, and we have to then address the claims without what's called in one of the cases, which I'll take my lords to, with no agenda for trial. We don't know which event it is, and therefore we don't know, is this under the OPA? Is it under common law? Is it the result of third-party interference, for which it said we're responsible? Has it been remediated? And that's something that we need to know, because that's a defence under the statutory claim. So these are the reasons why it matters to us. But the claimants are able, on this hypothesis, on this theory of global claim, to proceed without specifying that, but then they suffer the risk. They can still, but there are two further changes that are very important to note. So two mitigations which are important to note. Miss Day referred to one of them, and it was referred to by Mr. Justice Aikenhead in the case that she took you to. And that is, you can find at the end of a case that actually you can isolate a particular piece of loss and say that you can treat that in a particular way, though you're not treating the rest of it in a particular way. You ring fence it, or you award damages, or you reduce the claim by, I think in a particular case it's reducing it by £5,000 or something like that. So there is a way of reducing it. But the other way is by allowing the claimant, if further information comes to light, then to amend. And Mrs. Justice May referred to both of these mitigations, and I like to take my lords to them because, for one thing, it mitigates what otherwise I appreciate is seen by my lords as a very harsh doctrine. She does that in her judgment. Let me just find the reference, my lords. So it's the same judgment. I'm just trying to identify.
Well, in March 2024.
Let me just check that it is. I suspect my lord's probably going absolutely right. Yeah. Paragraph 45. So yes, it's what I call judgment 2. It's It's actually the November judgment. Not March. I'm sorry. It's core bundle tab 4, page 24. So paragraph, it's right to take it in the context of paragraph 44. Despite Mr. Hermer's rejection of the claimant's cases as global claims, I consider this is nonetheless what they are on the present state of the pleadings and associated information, with the exception of the 5. My lords can see that. But if my lords would just go back then to put it in context to paragraph 34. This is where she said she wasn't going to strike out the claims. And that was striking them out for lack of proper particularisation.
Is that really an application which you made on the hoof orally?
Yeah, well, if you read the whole of the transcript, you'll understand why.
Quite ambitious.
Given what the learned judge said, it seemed to be the route we were being expected to take.
Right.
We were it didn't succeed, as you know, which is very well known. But she's identifying at paragraph 45 one of the mitigations of the global claim result, which is the Aikenhead variance minimum code. And then she also recognises, and I'm just not immediately finding the paragraph, which she says will be amended.
44.
Oh yes, I'm sorry, it's staring me in the face, of course. In the middle of paragraph 44, if in due course further claimants are able to tie their case sufficiently to enable identification of a specific instance causing or possibly any material contributor, then there will need to be an application to amend which will be considered. In other words, at least two routes to get out of the problem. One is to plead the case, therefore, with more particularity, so it's no longer a global claim, that's the only thing that's on the table. And secondly, in any event, there will be an ability to mitigate in the way that Mr. Justice Waxman and Mr. Justice Aikenhead said. So it's not automatic that it will be struck out, despite the way the language has been used in some of the argument.
There may be a distinction between describing the whole Bille litigation, individual Bille claimant litigation, as a global claim, and saying that each claimant's claim, other than the five, is itself a global claim. Supposing that each claimant's case, say Mrs. Okile's claim 763, is properly described as a global claim, why is that a reason not to select 12 or whatever number of those as lead cases?
Well, I may be misunderstanding, but unless it were ordered or accepted by the claimants that they were global claims, then they're not. Then those different claimants would be distinguishable, so they wouldn't carry the result with them to other claimants. I'm obviously misunderstanding my Lord's question.
Well, I'm obviously completely misunderstanding what the judge thought she meant by, on the basis that they are global claims, i.e. all or nothing claims.
Yes. Well, she meant by that if each individual claimant, if each individual claimant is saying, or any individual claimant is saying, I rely upon all these events, I'm not going to say which, for whatever reason that may be. If then they lose, they fail to show that all of those events were caused by the defendant, or that the defendant was responsible for all of them, then they've lost the global claim, because the pleading has been, I rely on A, B, or C, you're responsible for all of them. If it turns out the answer is not A, B, or C, but D, then that's not the claim that you've put and you fail. That's what I'm saying, is simply, that's what the global claim is saying. Not particularly construction, not particularly Scottish. The reason it arises, and this is what Lord McFadden says in the Doyle case, the reason it arises commonly in construction cases, because those are the cases where it's common to have a number of events which sort of produce, or could be said to produce, the loss that the party is referring to. There's nothing specific otherwise about construction that makes it apply, and that's why Mr. Justice Waxman in the Alame case was right to say there's no special construction law that this applies. It's just a common occurrence.
But there is still, if it's the right order in this case, against the wishes of the claimants, then it's the first case ever in Britain in which such an order has been made.
Yes, and what the judges said was, I know you don't want to raise this, but that's what it is. It's an objective question as to what it is. You're entitled to bring any claim you want, but once you've brought the claim, it must be for the court to determine objectively what it is. I mean, and then if you don't want that claim, you have to do something about it. We say in this case, you tie yourself to specific events rather than saying it's everybody and everything. I hope that they all turn out to be right. I hope that not all of them, but one of them turns out to be right, then you win. That's the open-ended nature of the claim, which we object to. Open-ended nature of the claim leading to open-ended disclosure. Can I just... I've... yeah. So, could I take my lords, and I said I would come back to the April 2022 judgment of Mr. Justice O'Farrell, yes, which is in Supplemental Bundle Volume 1, Tab 4. So, her analysis at paragraphs 15 and 16, well, paragraphs 13 to 18, where she summarises the claimant's pleaded case. I'd like my lords to look at that. Then which identifies a number of cases that are there, and you can see that, particularly paragraphs 15 and 16, and 17 in relation to Ogani. Then, and paragraphs 24 to 32,
forgive me, Lord Goldsmith, I got distracted by following something else. Where are you?
I'm in, this is Justice O'Farrell's judgment.
Thank you.
Of April, yes, with anyone, of course. It's page 34 of the judgment, whether it's the same number in the bundle. Yes, it is.
Thank you.
And if we move on to pages 34, 36, she sets out the rules. Relating to GLOs. And at paragraphs 33 to 42, she addresses the directions consequential on the GLO, including the contents of the schedules of information, and the schedules are addressed further at paragraphs 40 to 58. Now, unsurprisingly, she takes as her starting point CPR 16.41. And that sets out the starting point, the requirement that the particulars of claim must contain a concise statement of the facts it sets out the requirement there should be a concise statement of the facts on which the claimant relies, including all the facts necessary for the purpose of formulating a cause of action. I'll come back to that in a moment. She then cites a number of cases so I sort of direct my Lord's attention to paragraph 59 in particular to start off with, which is the starting point I just referred to. This should include all the facts necessary for the purpose of formulating a complete cause of action. She refers to the cases cited in paragraph 60. I invite my Lords to read that, setting out what statements of case must include. She refers to Practice Direction 19B at paragraph 61. And importantly, paragraph 62 noting that group litigation and a GLO does not exempt each claimant from the requirement to set out in a schedule to the group statement of case or in a questionnaire or other, or in the group register the facts necessary for the purpose of formulating a complete cause of action. In other words, the fact that it's a GLO does not exempt you from the requirement to set out all the essential elements of your cause of action. It could be in your schedule, it could be in the general paragraphs.
Yes, we now have the schedules, of which we have
Yes.
2 examples.
Yes.
But you say those are inadequate because they don't identify a particular spill.
They don't limit themselves to a particular spill and therefore they don't identify the spill. Yes.
Right. And they say in the voluntary particulars that it's not possible to tie a particular claimant down to a particular spill because oil flows through the system.
Well,
and you,
they give their
you say
reason.
that's sort of absurd.
Well, I would say it's absurd. We don't accept it.
That was your facial expression, anyway. Yes. Right.
It's my facial expression. Yes.
The issue, as I understand it, is not whether the claimants must plead all the facts necessary for the purpose of formulating their cause of action, but when they should do it. The claimants accept that once lead claimants are identified, they will have to formulate a case identifying the spills on which they rely. The question is whether they should be required to do that before they have all the material that they say they need in order to do so. I appreciate you say they have, and they say they haven't got that material. But in a case which is obviously not a frivolous claim, where there is at least a reasonable argument that they don't have that material, but that you could give it to them by way of appropriate disclosure, why should they be shut out from pursuing the claim at all, just because they can't do it now?
But they're not being shut out from pursuing the claim. They're not being shut out from pursuing the claim for a couple of reasons, but one of them is because they can rely upon a global claim and therefore proceed forward by relying on all that they can and saying, but they then are subject to that regime, unless they then amend later or find a way of narrowing their case in the way that Mr. Justice Aiken has. So nobody's shutting them out.
Well, they're forced to go down a global claim route, which they don't want to go down, which has implications for the case management and disclosure that they're going to get, which is limited by the judge, in ways which simply puts off the day, they say, when they'll be able to formulate the claim they want to make. And they may find that they've then had the 3Cs trial and that their claim's being kicked out on a global claim basis. That's what's concerning them.
Well, my Lord, the 2 answers I really want to give to that. First of all, the answer to the question, when should the claimants plead the essential cause of action? In the standard pleading practice, you do that when you start the claim. That's what it should be, not at trial. I mean, our system has never operated on the basis that you wait and see and get to trial and then hope that you've enough has emerged that you can make a case good. Secondly, and that's what I want to say something about, I'm slightly nervous about doing it, because it's basic pleading principles. My Lord Justice Stuart-Smith referred to what one learns in pupillage in the first week, and I'm reluctant to suggest that my lords have forgotten any of that. But secondly...
It all depends who your supervisor is.
Not going down that route, my lords. But secondly, in any event, what the judges were doing, in my respectful submission, was encouraging the claimants to do more to identify their claims than they've done, and then the difficulties that they would be faced on a global claim would not arise. But they've declined to do them. Mr. Hermer effectively said that's a choice. They've decided not to go down that road. And this appeal is putting them in a position, if they succeed, that they then have removed the pressure point of having to plead further and put the defendants in the position that they're exposed to, we would say, extravagant claims for disclosure and discovery. And if they can have it, we can see the next cases coming down the road, and the next one after that, the next one after that. It's a matter of public policy as well, not to be subjected to these sorts of claims without a claim being put forward. And having said that, of course, I accept it doesn't mean that the claim is stopped at this point, precisely because, that's why I said it's an escape route for the claimant. The claimant who can't plead it, he's allowed to do it in this way.
We're not hearing an appeal from an order for standard disclosure, are we?
Well, you're being asked to make. Sorry.
Let's go back to Mrs. O'Keefe. The schedule of information tells us where she lived,
Yep.
and that the main fishing sites she used were Polongio, Toru, and Nabasi.
Yes.
Nabasi.
Yes.
So suppose she were one of the, and she says that the oil spill surfaced sometime in June 2011, and she thinks it came from somewhere close to Awoba. So if hers was one of the test cases, the defendants might say, I don't know, there was an act of sabotage close to Awoba, as demonstrated by a JIV report on the 31st of May 2011, and that's the explanation of it. Or there was a leak from a Chevron pipeline close to Awoba 3 months earlier, or something like that. The claimant's expert might say, well, that's possible, but it may have come from another spillage 3 miles away or a month earlier, and the defendant's expert might say stuff and nonsense, there's no way that it could have got from A to B. And you would do this for each of about 10 or a dozen claims, and that process would not be unmanageable and would reveal quite a lot. I can't see why all this is put on such a sort of apocalyptic basis that it's impossible to try lead cases fairly.
We need to have some tethering of the claimant's cases, not just completely at large, that they can rely upon anything which turns up, and they can get discovery as to everything in order to try and make that good. My Lord has said in that example that the claimant's expert will say, I think it's more likely it was from here. Fine, but then that should be done now rather than at trial. And that's a principal criticism that we have of the proposal that's being made. We don't see where they can't get on with getting their expert assistance and pleading what they think their best case is, and then we can proceed. And then we can respond to a particular allegation. We can't even say, my Lord puts the example, we would then say, well, there was a leak from Chevron at about this place. We don't know that's the spill, or that's the area of the spill that they're relying on, because particularly when they when oil is movable, when we've got the third-party interference and the illegal bunkering and the illegal refining, then the risk is we won't know which claim it is. What our complaint is, they shouldn't be simply saying everything. They should be narrowing this down with the assistance of the information we've provided, with the assistance, if they need it, of additional specific disclosure, though we've given them quite a lot already, despite what my learned friend says. Mr. Willand will expand on that. And produce a more focused case so that we can have a proper target to respond to and a proper agenda for trial, which is one of the phrases which is used in the cases on the importance of pleadings. That's what pleading is for, is to not just, it's to identify not just the case, but also the agenda for trial, the focus for trial, and that's not what they're doing at the moment. Would your Lordship just give me a moment?
Yes, of course.
Which paragraph, please?
62.
So, well, I thought I'd take my Lords to this, but could I just remind my Lords what paragraph 62 of Mrs. Justice O'Farrell's judgment says? Perhaps I never got here, the page here, perhaps I never got here. It is worth just spending a few moments on these paragraphs. Having set out Practice Direction 19B, having set out the requirement of CPR 16.41a, Mrs. Justice O'Farrell says that the claimant's not exempted from the requirement to set out the facts necessary for the purpose of permanent and complete causal action. And what I hadn't taken my Lords to is the decision in this court in Prudential Assurance and Revenue and Customs, General Lord Justice Lewison. And I think it's sufficient to note that the passage that's quoted there, the need for the particulars to comply with CPR Part 16, relevant factual sounding. And then the next case, which is also of this, oh, it's Mr. Justice Henderson actually, following the NEC semiconductors case. Mr. Justice Henderson said, my Lords will see the paragraph in paragraph 64, where multiple proceedings are managed through a GLO, the individual claimants must still satisfy the basic pleading requirement of setting out the material facts relied upon and the course of actions to which they relate. Now that's the originating process, not end of trial, not the final sort of written speech or something like that. It needs to be there. It should be there. And it's not right. It's not in accordance with the discipline that this court should expect of pleadings and cases to leave that all to turn out at the end with the possibility that there will be changes and shifts in position, different views, different claims being produced at a late stage. And that's why she says at 65 that the current pleaded case is a global claim. For the reason that she gives, they've identified a number of oil spillages, described the damage suffered as a result of consequential contamination, but they've not pleaded any causal nexus between each spill and the damage suffered by individual claimants. And that's one of the requirements of pleading. They should be saying not just what the events are, but also what caused their loss. Now, they can get away with a global claim because they can say all of these things caused our loss, all of the events in Bille caused our loss. It's a rather extravagant assertion, but they can say it and the pleading will meet the requirement. But then at some stage, what happens if they can't establish that? And that's where not a catch-22, it's the problem, the difficulty, which Mrs. Justice O'Farrell told Mr. Homer about right at the first time this was raised, of a global claim. Instead of going down the route of trying to particularise this more more carefully, they're content to proceed on the basis, well, we pleaded everything, so we'll stick with everything, and we'll get discovery for everything, and at trial we'll see where we are. You'll know what the case is when you get to trial. My lords, that's what we object to, and that's why we've stood on this ground.
Yes. Of course, matters have moved on somewhat since Mrs. Justice A. Farrell's judgment, in that the claimants have now provided the schedules of information. So we're looking now at a combination of the particulars of claim amended, or if the claimants are successful on the first appeal, re-amended form, plus the schedules of information. But you say the schedules of information are inadequate in that they say who claimant is, where they lived, and so on, but don't identify the spills which are relied on.
Well, they do, but they identify all the spills, because that's what the voluntary particulars do. Because they say rely on all. So in a sense, they've got a tick next to that element, but it's a tick which is fraught with difficulty and which we shouldn't be faced with. My lords, then, can I, following 65, which I've taken, my lords, 66 is where she refers to the Aikenhead exception, as it were, setting out again from Walter Lilly, but also from John Doyle.
Forgive me, just going back to 65.
Yes.
In 65, she is describing the whole thing as a global claim.
Yes.
Not a collection of 2,000 individual cases, each one described as
Well, I'm not sure the distinction was being seen. I was putting my submission to my lords, which is, my submission is it's each individual claim which is a global claim, because it's each individual claimant who's claiming in relation to all the spills without specifying further. And that's why it wouldn't sabotage, it wouldn't torpedo an individual claim if someone else failed. Just not for that reason. So my lord, 65, I may move past that. 66 is the point I've been trying to make. It is permissible to advance a claim as a global claim, and she identifies the Walter Lilly case, Mr. Justice Aikenhead, but then the risk. And it's very important, and I'm sure my lords have read, but I would invite them to read again what was said by Lord McFadden and John Doyle, which is the logic of the claim. And then saying in paragraph 37, quotation 37, that's why it's a risky enterprise. This is not a Scottish statute, as I'm trying to say. This is just a matter of logic and pleading. And then I wanted to get to 67.
It isn't logical.
Sorry.
It isn't logical to assert that unless all the events which contribute to causing the global loss be events for which the defendant is liable, the claimant loses. Because it ignores the possibility either of concurrent tortfeasors or concurrent causes where one is not a tortfeasor.
Well, that's why that's part of the Aikenhead exception, if I may say so, which is that if when the evidence is there, you can see that actually the claim, we haven't got it here.
I don't think it is the Aikenhead exception. It's certainly not carving out part of the damage.
Well, I think it's I read it as a general statement, but be that as it may, the important point for my submission is that the claimant has relied upon all these events and hasn't had a claim which had all those said you're responsible for this because you're responsible for all these events. If it turns out that's not so, then that claim fails. That's the point, and it's a point of logic. It can be rescued and mitigated in a number of ways, and maybe the way my lord puts it, maybe a further one.
That's if it's a Wiltshire case, where you've got a number of different causes, each of which on its own, and you can't tell which is the probable cause. But if you find that, say the claimant identifies 5 things which it says are causes, almost by definition, by saying that they're concurrent causes, if you find that the defendant is responsible for 4 of them, you go straight into a conventional analysis, which is, on the balance of probabilities, is it causative? And then unless you get into Wiltshire, then the claimant still succeeds.
Well, my lord, that may be so. And
well, that may be so is not a very satisfactory response after 3 days, where what we're arguing about is whether, if they fail to prove one thing, that they fail completely.
Well, my lord, I respectfully don't think we are. The declaration is to describe this as a global claim. And
the claimant's claims are to be progressed on the basis that they are global claims.
Yes.
I.e. all or nothing claims.
Yes, that's how it's described. Absolutely. That's the description of the claims. What then happens to those claims when we get to trial is a different matter. That's why the Aikenhead exception is one. That's why in paragraph 76, sorry, not 76.
Just remind me where the Aikenhead exception is.
I'm sorry, my lord?
Would you just remind me where the Aikenhead exception is set out?
Yes. Yes, we find it best in the judgment of Mr. Justice May, but my lords were taken to it.
Yeah.
And perhaps can we just turn up Mrs. Justice May's judgment on that?
Yep.
This is the May 1 or May 2?
May 1.
May 1, right. November 23.
Yes, November. Paragraph 45. So that's the, we can take you to Lillian Mackay and the Mr. Justice Waxman's, sorry, Mr. Justice Aikenhead's exception, as it were. But she also makes clear they're still at liberty to amend their claim and avoid the problem altogether. So there's both routes. Now, in what I've been saying, it's inherent in what I've been saying as to what the requirements of a proper pleading. So that's the thing that I'm slightly reluctant. But may I just cite a couple of cases? The starting point, of course, is 16.4.1a of the CPR, which we've referred to already, that you have to have a concise statement of facts on which the claimant relies. In King and Stiefel, we've got that at authority tab 29, if my lords want to take it up. There's Mrs. Justice Cockrell. So paragraph, pages 1216 to 1217, that's paragraphs 145 to 148 of this judgment. This is Justice Cockrell refers to the three purposes of a pleading.
I'm so sorry, which paragraph?
Paragraph 145, on page 1216 of the bundle, the hearing of the judgment. So the essence is paragraph 145, three purposes. First is best known, enables the other side to know the case it has to meet. That and the second are both referred to in the speech of Lord Neuberger in our Roy. And the important quotation from Lord Neuberger: a party is entitled to know, normally through a statement of case, the essentials of the opponent's case in advance, so that the trial can be fairly conducted, and in particular the parties can properly prepare their respective evidence and arguments at trial. Second purpose, paragraph 146, so the parties can properly prepare for trial. Which he refers to something Mr. Justice Tier said in Town and Wills. And paragraph 148, the third purpose of the pleading is less well known but no less important. The process of pleading a case operates or should operate as a critical audit for the claimant in its legal team that has a complete cause of action or defence. And then the 149, important paragraph, the particulars of the claim should generally aim to set out the essential facts which go to make up each essential element of the claim of cause of action. Without that, it's liable to be struck out.
This always looks, with respect to Mrs. Justice Cockrell, far from being innovative. It's what we've all been taught for decades.
I think I start.
It's how it should be applied to the present situation.
Well, not, of course, but and I did make that sort of apology before getting down this road precisely for that reason. Yeah. But it's not apparently what's understood all the time, and it means that the claim has to say what the event is which has caused the loss. And that's what we were asking for. And now the only answer we've got now is all of them. All of the things which happened in Bille. That satisfies the strict requirement to say what the cause was, but it leaves us in a terribly difficult position. And it's no answer to say we won't know, you'll know by the time we get to trial. Paragraph 153, just to notice it, that again, it's nothing particularly innovative, I respectfully agree. It's the starting point is the target at which the particular claim should be shooting.
This is quite an exotic case, isn't it?
How are we?
Well,
it was.
The one we're looking at.
Yes, yes. And at paragraph 198, as we think a happy expression, because she talks about, she reminds us, sorry, this is so basic, the causation of loss is an essential part of the cause of action of all claims in tort, obviously. And at 200 at the end of it, she says that the act complained of and the loss must link up. But Mrs. Justice may refer to that as the basic tort join-up. And of course, none of this should be controversial. And if an individual claimant brought this claim in relation to a single event, the individual will have to plead and prove that the event caused the loss. And I don't think the claimants dispute that they would have to prove that these events caused their loss. What we've been saying is we need to know what it is, and it's no answer to say it's all of the things which happened in Bille, unless you're unless you do it on the basis of a global claim, which satisfies the requirements of pleading, but leaves you in the difficult position, the dangerous position that you're relying on all of those things, and therefore you're at risk of losing if you can't establish that. And I've made the point, I think I was going to make it good just in case there's anything said in reply. The pleading rules are not relaxed either because it's a GLO or because there are a lot of claimants. In the Tesco shareholder litigation, I'll just give the reference to that if I may. It's Authorities tab 34, page 1513. Mr. Justice Hilliard said that the fact that there were lots of claimants didn't relieve them of the need to fulfil these requirements. The fact there were lots of claimants and the fact there was it was a GLO. And I've already said that the CPR rules specifically envisage that GLO particulars of claim will be served in all cases. And that's Practice Direction 19B. And Lord Justice Lewison in the Prudential Assurance case, I'll give my notes the reference, Authority Volume 5, tab 47, page 1905, paragraph 17 to 18.
78.
17 to 18.
Thank you.
It's very clear. And I've already made a reference, or the learned judge made the reference to Mr. Justice Henderson in the Europe Car and HMRC case. And that's in the Authorities, Volume 3, tab 18, page 797, particularly page 48, which is at page 818. Just reading, even where multiple proceedings are managed through a GLO, the individual claim enforcement is not satisfied. The basic requirement of pleading, setting up the dual factual liability. And the third point I wanted to make, the group litigation cases to date show that proper particulars of the essential facts must be provided in advance of the selection of lead claims. I'll refer to a couple of cases, and they're slightly slower. Varney and Ford, which is Authorities, Volume 6, tab 64, page 2471.
2471.
Decision of Mrs. Justice Asprin, as her ladyship then was. Now, she required all 1,400 claimants to give details of their claims before the selection of lead claimants. And
Sorry,
it's
yes.
Varney.
What paragraph are you referring to?
I was referring to the case generally, but I'm going to go to paragraph 35, which was the issue that the ladyship had to consider, where the submission was made that the details of 150 claimants would be enough, but the response to that from the defendants was that in paragraph 36, about 3 lines in, Mr. Jeans said that the defendant's level of satisfaction in relation to the 10 test cases for trial was dependent on being able to determine that they were a proper and appropriate sample in the first place, and determine who is a representative, what is specific, and what is generic can be done if all the information is collated in the first place. And he said it was important to have all the claimants committed to their case at an early stage. And at paragraph 38, despite the fact of which she was mindful that there were a number of claims and the cost and time involved in collating the information, she rejected the idea that the lead claimant should be limited to, the particular should be limited to 1,400 odd claimants. paragraph 39, it's, in any event, despite the cost involved, it's appropriate all the claimants should provide details. And notes at paragraph 40 that the collation of all the details gives a sound foundation to the litigation as a whole and to the choice of 10 test cases. It avoids the possibility of further applications and the wasted costs that would cause in court time and further additional delay dealing with further inquiries which might be required at a later date.
Well, it all depends, doesn't it? I mean, this case of Mrs. Justice Aslan's is a claim for negligent misstatement in relation to employees transferring their pension benefits to a new scheme. So you ask each claimant what was the negligent misstatement on which you relied. And, that doesn't seem to me very oppressive, but at least the answer couldn't properly be, I don't know. Whereas in this case, the claimants are saying, rightly or wrongly, I can't tell you which spill caused the damage.
My Lord, not from personal recollection, the point that was made by the judge. But at some point, they undoubtedly will be particularising and specifying it. I think my Lord put to me, is it a question whether it's now or then?
Yeah.
We object to it being then when it could be done now. Or at least much more could be done.
If we accept what we're told by reputable counsel and solicitors, they cannot, at the moment, identify individual spills for the vast majority of these claims.
Oh Lord, I very much regret, and it's no aspersion on this day. No, we don't accept that because we believe.
No, I didn't ask if you accepted it.
Oh.
I said if we accept.
Oh, I'm so sorry, my Lord.
What we're told.
I jumped to that. No.
Then surely you not having struck out the claim and you, I think, inferentially accepting what I think Lord Justice Mail said, this is not a frivolous claim. We have to find a way to break this deadlock. Can you suggest any other way of breaking the deadlock?
Well, Lord, yes, and that's largely what Mr. Willan will do, but I summarised it a little bit. We think that with the information they already have, and with further information, if they believe they need it, obtained through an application for further disclosure, and with the assistance of experts, they could be more specific at this stage and not leave it to the trial, which will be horrendously late and cause a lot of hardship to the defendants.
Thank you.
And in terms of the selection of lead claimants, that's what Mrs. Justice O'Farrell decided, and that's what Mrs. Justice May decided, the managing judge, that in the light of all the circumstances, she didn't accept that they could identify lead claimants reliably at this stage. The risks, if you get it wrong, are substantial. If they were doing it a different way, well, there's lots of different ways that these things can be done, but they ought to be able to identify what their claims are, not just
All of them.
Well, my Lord, yes, all of them.
Yes, you say all of them.
Yes.
All 2,200. And until then, no lead claimants can be selected, and if there has to be a 12-month trial with 2,000 witness statements, well, too bad.
It won't be that. What we're asking for is more particularisation of the claim at this stage. We're
They
not
told
saying
me that was the premise of my question. They tell us that they cannot do that. Now, you say they should be able to do that, but they say they cannot
Well,
do that.
my Lord, we've set this out to some extent, and we'll have to examine the evidence in relation to it. And this was where we took exception to them saying they couldn't do it, because and Mr. Herman didn't say they couldn't do it. He said they didn't want to do it.
Well, I think life's moved on a bit since that
Well,
sentence.
my Lord, No, with respect.
Yes, it does, because you may criticise the reason why they hadn't done it before, and we can make up our minds about that. And that's the Hermer sentence about that being on the CFA. But we have to deal with the case now, which is why I asked you what you proposed.
Well, that's why I tried to answer the question.
Yes, you
My
did.
Lord obviously doesn't find it terribly satisfactory, and therefore Mr. Willen will make it much, much better when he comes to address your Lordship tomorrow. But seriously, I mean, we don't think it's right to say you throw your hands up and you can't do anything at this stage. The explanation that has been given as to why they can't do it now, we respectfully don't find satisfactory. Of course, I understand that your Lordships say, well, you might do. Well, that's for your Lordships to decide. The judges below, neither of them found it satisfactory, and that's why we're in the position that we are.
There's one thing to say that the explanation is not satisfactory, and that you may say that it's not a good reason they've erred in the way that they've conducted themselves. But I do not understand you to say that you invite us to reject the clear statement by leading counsel that they cannot do it at the moment.
With respect, my Lord, we're back to Miss Day, whom I have, of course, enormous respect. She's now in my own chamber, so why should I not? But the fact remains, it's not her that has investigated this or done it. It's others that have done that. And so it's not any reflection on her. It's not one of those cases where counsel is telling you something from the bench about the law or something. It's a fact. The evidence which I invite my lords to look at, the evidence that we have put in, takes a different view as to whether they can do what they say they now say they can't do.
And I'm conscious we haven't heard Mr. Willen on the detail.
And my lord is great.
Perhaps it's come down to quite a narrow issue. I think you accepted in response to my suggestion that you were saying that if the case had to be tried as a mega trial with 2,000 claimants, that would take forever, that would be inappropriate. So if this case is ever to be tried, it will have to be on the basis of lead claimants being selected. But you say that it is unfair on your clients for lead claimants to be selected until the claimants have provided particulars of causation in every case. That's the area of dispute, isn't it?
Will your lordships just give me a moment, because disagreement behind me. It is being suggested that I invite your lordships to let us come back tomorrow morning on that question. It sounds quite a diplomatic answer if your lordship permitted it to be given.
All right. Well, that's a good moment. At what point do you expect to be able to hand over to Mr. Willens? And then the second question would be, at what point does Mr. Willens expect to conclude his submissions?
Again, let me just think about this. I've taken my submissions a bit out of order. I still have a fair amount to do. So, 3 hours tomorrow morning. I think under the schedule, though I know this may not be what my Lord Justice wants to hear, what an intervention earlier. I think the schedule this day is due to be back on her feet by 3 o'clock. But on the timetable.
Yes, although I use less time, so I do actually have some more time back on my side, but we can work that out.
Oh, I see. Let's work this out.
So we can speak, but I did use less time than I had today. But we're also conscious that you've indicated you'd like some time to discuss it between you. So I suggest we see if we can also achieve that.
That's what I was referring to.
All right. Well, on that note, we'll rise now and resume at 10:30 tomorrow.
What lies agreeable?
You don't want to start at 10.
Sit down again, everybody.
But not if we're still going to use all the time.
Yes. A possibility.
I would ask that we don't. I actually had a child throwing up all last night, and I have to deal with that. So if that's okay.
10:30 tomorrow.
10:30, please. Thank you. The live stream is still running.